so it's not quite feeling like fall today, but you know.
But it is fall,
so
we'll take it. You know, we've got some cooler weather, at least when the clouds roll in, it doesn't hit 90, so there you go. Tomorrow, that's not the case, though. It's going to be a quick warm-up, plenty of sunshine. We're already at 70 degrees at 7 a.m., 79 by 9 a.m., and headed up to around the low 90s, so maybe 1 to 2 degrees cooler than it was today. Only 90 degrees Tuesday, so, you know, it's trending cooler. I just want to reiterate, though, check back on that forecast Thursday and Friday. It could drastically change, honestly, as the tropical system begins to get its act together a little bit more. We'll kind of know if we're going to get some much needed rain here in the Tennessee Valley. I really hope we do. All
right, fingers crossed. Thank you both so much. WAAY 31 gives you 24/7 coverage. You can count on local news, breaking news, and severe weather. Don't go anywhere. WAAY 31 Law Call is next.
This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight it's You Be the Judge night. We're doing something a little different tonight. We have got an attorney who is also an author. He has written a book with 50 real-life legal cases. We're going to introduce you to the facts of some of those cases. He's going to walk us through them, and then you be the judge. What do you think the outcome should have been? You can call in questions about the legal process or your thoughts on these cases or any kind of legal thoughts you have tonight. The 31 Law Call number, 256-536-0077. You can call. You can also text your response. Maybe you've got thoughts when we give you this case, a couple of cases. Tell us what your thoughts are. Text us to that number, or you can also email. You email any legal question any day of the week. You send it to lawcall@waaytv.com. And when we get to a show that's on point, we'll have some of those, and we will have some of your email questions and thoughts tonight. We've got Michael Timberlake here from Timberlake, League & Brooks. Good to have you here.
It's good to be here.
We love to give people facts, and you be the judge. So before we get to the cases and the book, very interesting kind of change of our style tonight. We like to always give you some video and start off with this one, a roundabout. Okay,
here we go.
Alabama's starting to get some roundabouts, and a lot of folks don't know how they work, including right here. Okay,
Yep.
Yeah, it goes out of control. We don't have a lot of roundabouts here, so at least the accidents that happen, I would think, tend to be less severe than, like, you know, not big T-bones and
Yeah,
things
this
usually.
is like a 2-lane roundabout, which makes it a little more complicated than most. But in general, you know, the rule in a roundabout is you go to the right, and you can't go to the left. And for some reason, this vehicle decided you know, got a little confused and decided to take out a couple other cars. But, you know, they can be a little bit challenging. But the benefit of a roundabout is you can't run a red light at a roundabout. You can't T-bone anybody in a roundabout. And even though this accident looks bad, you know, the injuries are probably a lot less severe than you would if you had somebody running a red light.
Yeah, and as we get more of these, and I think our city planners like these because it keeps traffic moving.
Sure,
We're going to get
sure.
more of them, so if you don't know how to do them,
Well, they make sense from a traffic engineering perspective because they're efficient and they're you know, there's less chance of an injury or an accident, and you also don't have to continuously maintain and update lights and things like that. So you know, it's a good thing.
So tonight, it's You Be the Judge night. So we've got a guest with us tonight. This is Tom Borcher. Tom has written a book called Justice in Your Court, and it is available. We're going to give you his website information. He's also got them. There it is. Tom Borcher, Justice in Your Court. It is 50 real-life cases, and he walks you through and tells you the facts of the case, but then he stops you and says, okay, how would you decide it? So whether it's if you're watching this show, you love the law and you're fascinated by things like Law and Order,
sure.
Stories like this, and even the family can get into reading a story. Tom, welcome. Glad to have you here.
Very nice to be here. I hope we have a good time. I've tried to find some cases that people might find interesting and a little twist to them, so unpredictable.
Tom was a personal injury attorney for years in L.A., and has been living in Alabama for 10 years now. So had some family down here and loves living in Huntsville. And spends all his free time going to the courthouses and watching cases. And once a lawyer, always a lawyer.
Yeah, really. Couldn't shake the practice. Even though I'm not practicing, I do like to go and sit in the courtroom and watch a full trial. It's better than television. I'm telling you, you ought to try it.
People think you can't do it. People are surprised to think you can just walk in. And do you mind having people watch your jury trials?
It's always fun, and and you can use them as informal consultants. There were, there's inevitably were a few people that were just known to be there most of the time when there's a jury trial, and so it's a lot of fun. It's other lawyers will sit in on jury trials, but it's open to the public for the most part, and they're entertaining and a little bit there's a little drama going on.
So Tom, give us a case. So give us a sample, and let's see. And feel free to call in and text us the number there. Tell
you
us
can give us
how
a
you
thumbs
think.
up or a thumbs down.
There you go. There you go.
Give us a sample.
Yeah.
All right. So this is a fun case, not for Miss Dauber, but Miss Dauber was a 68-year-old lady who really enjoyed dressing up when she'd go out. You would never see her in casual clothes, even at the grocery store, which is what happened when she went this day. She goes to the grocery store, parks her car right next to a parking meter, gets out of the car, walks over to the parking meter, puts her money in, and as she goes to step back, her heel goes into a metal grate that is right below the parking meter, about 6 inches below. And the grate then swivels, and she falls, and she breaks her hip. So pretty significant injury for a 68-year-old. She sues the utility company for putting the grate at that location with slots in it for the very reason that people don't look down at the grate, and if they're wearing heels or something, they could get stuck. She called as an expert at the trial, a guy who said, yes, when you're designing these things, you have to keep in mind that people look at the parking meter here. They're not looking down at their feet. The utility company comes back and says, and this is one of the interesting facts about this case, hey, she was wearing stiletto heels at 68. So the very thinnest heel, we don't, we put the slots in the grate, they're small, but come on. They said if she's going to wear those kind of shoes, she needs to be super aware of where her feet are going. And we use these around town without a big problem. So on cross-examination, I might add, they said that there were no women on the committee that designed these plates. We kind of had a little fun with that. And that they replaced the grate with a solid one after this incident. So.
Ooh. Okay, so that means something to you, right? If they've made changes since then.
Well, yeah, this is there's a lot of things going on here. It reminds me actually of a big problem we've had in downtown Huntsville
around the courthouse,
with all around the courthouse, with the bricks that were laid there, and the female attorneys would inevitably on the way to court get their heels stuck in the thing, and
ruin a lot of shoes if you don't fall and actually hurt yourself.
Very upset. So so this is a unique situation, and in Alabama, what we deal with is the premises owner has an obligation to make it reasonably safe, but the person that's on the property, has an obligation. If something is open and obvious, and somebody else, you should have seen it with the exercise of due care, then it is a defense that the premises owner can use in Alabama.
I think it's a thing too that you're having to look at putting the money in. You're distracted. You're certainly not going to be looking down there.
Sure.
How long ago was this case? Because I wonder if that's going to make a difference in
probably
how
11 years ago.
Oh, yeah.
The interesting thing about the replacing the grate is normally in a trial, at least where I practice, I've never practiced in Alabama, but normally in a trial you cannot put in evidence of a subsequent remedial repair because it inhibits people to make those safety repairs. So the courts won't let you do that, except if the defendant says it was perfectly safe, we just replaced it, then that's what happened in this case. Was they said it wasn't dangerous, but we put in a solid one just because we wanted to. But had they said, well, we did find that was dangerous, we wouldn't have been able to get that fact in.
Right. That's the remedial measures are always one of those things that you always fight to get in as a lawyer, and you're always trying to come up with a creative way to make that happen.
So did she win?
Yeah.
Well, they mediated the case, and the mediator awarded her $75,000.
I got you.
Went to trial, and they defensed the case and found in favor of the utility company instead of Ms. Dauber.
Really?
She was a little feisty on the stand, so I'm not sure she won any hearts. She would go to battle with the defense attorney. She's a very interesting lady.
Well, and then, you know, in Alabama, which is different than California, we have a law called contributory negligence. So that if you do something to cause or contribute to your own injuries, such as maybe wear stiletto heels in an area that's a little more dangerous than it should be, then a jury can say, hey, this is really just your fault. That's, you know, don't have recovery.
Very interesting.
Yeah, we had comparative fault in California, which is percentage-wise. So if they were to find the plaintiff 25% at fault, reduction of damages by 25% would occur.
Yeah, it's an absolute bar in Alabama, but other states have it's a much fairer system.
I don't know how you guys do.
It's what we got to deal with.
Yeah.
Even retired from doing the law, you still enjoy going to not only research cases, but go watch cases.
Yes.
I think you must have a real respect for the lawyers that are trying cases.
Oh, I can sit there and maybe be the only person in the courtroom other than the lawyers themselves that know how much work went into that case. The lawyer's credo is never ask a question that you don't know the answer to. So all those questions you hear the attorneys, presumptively, they already know the answer. And to put all that together and to plot your alternatives, it's complicated, but so much fun, I gotta say.
Yeah, I mean, trial work is a delight. It really is fun. It's kind of like putting it together a play, and then you get to go present the play. Unfortunately, sometimes you settle cases and don't get to get to that point. So it's it can be taxing.
How do you find cases to go watch around here? So if you love Law and Order and all those kind of shows, you would probably really enjoy watching some cases, and you can do that for not juvenile cases, but even divorce cases. You can go watch trials.
The way I do it is I go to the Madison County calendar, their court website, and look at the calendar, and it'll tell you when jury trials, the weeks of jury trials, and those are the ones that you want to potentially go down there. Best to go on a Tuesday. They're picking the jury on Monday, so it's best to go on Tuesday because sometimes they won't let you in the courtroom. They're so crowded. But
judges enjoy having an audience. They really do. They'll make you welcome.
And the clerks usually know what's going on in the courthouse. So they, if there's a really interesting trial, they can give you a heads up. They'll say, go to courtroom 2.
Yeah. You probably can't bring popcorn these days.
No drinks or food in the courtroom.
Bottle of water and that's it, but it's the best entertainment. Okay, we're going to take a break. Call in your questions, your thoughts. We're going to give you another case in just a minute. The 31 Law Call number 256-536-0077. Be right back.
watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Meservey. And hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. Tonight, something a little bit different. It's You Be the Judge night. We have got a retired attorney who has written a book of real-life cases. So his book, this Tom Borcher's book, Justice in Your Court, and it is available. Tom, where all can I get your book?
Well, Harrison's on the Square carries it. You can also go to my website. I have an author website, tomborcher.com. And you can order the book. You can actually read an excerpt from it if you want to. There's some reviews there. So that's a good way. And it's on Amazon as well.
And you don't have to be a lawyer for this. This is written for people who love Law and Order TV shows and stuff. What do you want people to do with your book? Because it's a little different. You give the facts of a case.
And I think it's timely at this point. I want people to have the sense that there are two sides to every argument, and to have the consideration and respect to listen to the other side. That's why I chose the cases that have that twist, because it makes it kind of important to really pay attention to all the facts, and to be, especially younger folk coming up, to have respect for other people's opinions and to understand where they're coming from.
You've had a few people tell you they read these around the dinner table?
Yeah, that always struck me as interesting. But yes, I've had people tell me that they use this as a family game, and they'll sit around the dinner table and read a case. Or a lady told me they drove across country and she read her husband the cases and let him decide them. I can't think of a more fun way to spend your vacation. I encourage it.
Gives you something to think about. Okay, give
Yes.
us another case.
All
Okay,
right.
real life case.
Real life case. It's a little bit more serious. It's a death penalty case. It went to the Supreme Court, so now you're sitting on the Supreme Court, all right? Wilbert Evans shot and killed a police officer. He was convicted at trial of capital murder, which means the death penalty is in play. In order for the death penalty to be put in place, the jury must find one extenuating, aggravating circumstance in addition to the murder charge. And in this case, the jury found that aggravating circumstance was the future dangerousness of Mr. Evans, considering his past criminal record. So a concern for his future dangerousness, he got the death penalty. While he's in prison, there's a prison riot, and Mr. Evans comes to the aid of the guards and nurses that were held hostage. One of the guards later said, if it hadn't been for Mr. Evans, there would have been dead guards and nurses who would have been attacked. So Mr. Evans appealed that decision about future dangerousness and said, the jury got it wrong. There is no risk of future dangerousness. And the state agreed. The state admitted that the jury got it wrong, but the state said in the important interest of procedural finality, we cannot have people coming and appealing their sentences based on the fact they did a good deed on Tuesday. And now I want to go have a hearing because I'm clearly not a dangerous person, right? So that was the state's position, procedural finality. And that's the decision you have to make. Which is more important? The fact that the jury got it wrong and a man is going to the death to be executed? Or is it important that we draw an end to the procedure and move along?
That's a good question. I don't think it should be fair that the jury should be required to speculate on what might happen in the future and as an aggravating factor, against him. Look at what he did, judge it based upon the facts that are present there, and then make your sentence at that point. But requiring a jury to speculate on what could happen in the future, I think is a bad process to begin with. But in general, my suspicion is that the court affirmed the decision on appeal because once something happens in court, usually, unless there are very, very rare circumstances, it does not get overturned.
I think this is tough. If the state, if even you're saying the prosecutors were saying, yes, the jury got it wrong.
On appeal, they conceded the jury got it wrong.
Wow. Is the Supreme Court going to say this guy is still going to get the death penalty when even the prosecutors don't want him to have the death penalty?
Oh, no, the prosecution wants him to have the death penalty because they want to keep procedural finality in court.
Okay.
Right.
They don't want, like I said,
Everybody
every
coming
prisoner
back.
who
Okay.
does a good deed to come and say, look, I'm not dangerous anymore.
But they agree that
tough.
jury speculation was incorrect.
Yes.
You know, that's a difficult one.
I
But you're
did-
going to end up in a situation where, you know, you're looking at it from the judicial standpoint or the
floodgates
efficiency
are
of,
gonna open.
Yeah, you're going to you'd have to relitigate almost every case where this was a aggravating
Yeah.
factor.
I
That
agree.
was their concern, the state's argument.
Sure.
And it
Okay.
What
happened?
It won the day. The sentence was not overturned. The Supreme Court said that procedural finality is important to keep our system working. And Mr. Evans, unlike what would happen probably these days, Mr. Evans was executed the very night that the Supreme Court decision was made
Oh,
on
gee.
that. So it all
Wow.
happened
Yeah,
very
I
quickly.
was going to say I think probably maybe the better protocol there would be some type of clemency or some kind of
Yeah.
pardon and parole, some
Yeah.
kind of sentencing
Yeah.
adjustment as opposed to just ignoring what the truth was.
Justice Marshall dissented in the matter, and he said a death sentence that is dead wrong is no less so simply because its deficiency is not uncovered until the 11th hour. So that's another bit of thought for this type
He could
of
have
case.
used a good podcast, could have gotten an uproar.
Absolutely.
Why do you think people are fascinated with court and law and going to watch jury trials even when they're not working on those cases?
I believe it's because people like this thing of making a decision, somebody's right, somebody's wrong. I don't think it's any different than people who like to watch The Voice and decide which one of those singers is better. They hear the prosecution and they hear the defense, or they hear the plaintiff's lawyer, defense lawyer, and they're puzzled as to how will this come out, which is why I chose the cases I did in the book. That's the kind of case I wanted, was to have some like you two have said. Wow, that's a difficult question.
Yeah.
And that's why I think they like it. I don't think it's any different than the competition shows on television, frankly.
Interesting.
And I also believe the justice system is a fantastic system. I think it's just wonderful the way it works.
People will put down our justice system and say, oh, we need changes. Yeah. From your career, you feel like you, for the most part, got fairness, your clients got fairness?
There was very seldom any time that I thought a jury literally got it wrong. They might not have given me the dollars I was asking for. And I've been defensed a few times. And I had to admit that I knew that was a possibility. I think juries most often get it right. And most of the cases I sit through here now in various courthouses around here, I think the jury's got it right most all the time, frankly.
Yeah, it's amazing, what a jury, will do with a case when you try it, and it's always interesting to kind of see. My favorite part is talking to a jury after they enter a verdict, because you're always, what was the critical fact? And what I think is the critical fact typically was not.
Absolutely.
and it's just strange what they'll latch onto. So,
So they will they want to talk about it, don't they?
Oh, yeah, absolutely.
They'll stick around and talk.
Sometimes they will, and sometimes people are reluctant. Yeah.
There was a case that one of the other lawyers in my firm tried, and he got a good verdict. And he was talking to the jury afterwards, and the jury said, well, we would never vote for that other guy because the defense lawyer looked like Richard Nixon. So
you never
do
know.
get strange things with the jury, but there are 12 of them there to kind of mitigate that kind of thinking, I guess.
Right.
So we're going to take another break, be right back, and we'll tell you again where you can get Tom Borcher's book just in time for Thanksgiving. Sit around the holiday table. We'll be right back. If you haven't gotten your questions answered tonight, or you want to know more about Tom Borcher and his book, Justice in Your Court, it's available. Check out his website, www.tomborcher.com, or through the Timberlake League and Brooks website. He's also going to be doing a signing at Harrison Brothers Hardware the weekend of Thanksgiving.
Saturday after Thanksgiving.
Yeah, yeah. And you're also you speak to groups or events or churches,
yeah,
whoever.
If you've got any kind of group, I don't charge or anything. I like to come out into the community and present a few cases and let you all be the jury. And I'm going to give about 10 books to Mr. Timberlake here, and he can take them back to his office. And if you stop by, get a free copy.
Yeah, absolutely. Yeah, if you give us a ring or shoot us a text, and we'll figure out a way to get you a copy of the book. It's a great read.
I've gotten to read about 3 of the cases so far because I had it a week ahead of time. Very interesting. If you didn't get your questions answered and you've got personal injury cases, Michael Timberlake with Timberlake League and Brooks in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com, and if you like them on Facebook, you can learn more about the law that way.
And my friend Sharon is a family law attorney here. She practices in North Alabama. She does divorce, child custody, all kinds of different fun stuff in the family world. 256-539-7337 or SharonFamilyLaw.com.
Tom, misperceptions people have about lawyers. What are some misperceptions you think people have?
Well, I think one, especially for a plaintiff's bar where we're working on a contingency fee, this old ambulance chaser thing just irritates the heck out of me because working on a contingency fee, I don't get paid unless I win. So I'm going to take a case that has merit. It may not be a sure thing, but it's going to have some merit to it. If we took everything that walked in the door and we reject, I don't know about you, but we rejected more cases by far than we ever took.
Sure.
Yeah. Yeah.
You don't want to waste your time on something that's not going to work out.
On the other hand, I'm very proud of the fact that a contingency fee lawyer allows people who otherwise couldn't afford it to have a lawyer.
Yes.
Right.
Thanks for all of your time today, and look forward to hearing your thoughts and reaction to the book. Enjoy. Have a good week.